Hello, everyone, and welcome to the panel discussion on the topic of cross-border forensics and regulatory actions, a field guide in handling data. We'll start with a couple of introductions. My name is Brad Kolosinski. I'm a director in control risk, compliance, forensics, and investigations practice, and a member of the discovery consulting team based in San Francisco. Primary focus is on supporting cross-border disputes and regulatory investigations involving fraud, bribery, corruption, and criminal antitrust issues throughout Latin America, Europe, Middle East, Africa, and Asia. I will be moderating the panel today. I'm joined by my esteemed colleague, Antonia Carlin, who is a principal in control risks, compliance, forensics, investigations practice, and the head of our discovery consulting and project management team. Antonia is based in New York and is a former practicing discovery attorney with the law firm Cleary Gottlieb in New York, and has over a decade of experience in managing complex cross-border discovery matters, including financial regulatory inquiries into LIBOR trading practices in several quite difficult European jurisdictions, and one of the largest corruption investigations ever in Brazil. I'm also joined by Bob Kalo, Senior Legal Counsel at Nokia, and Bob is also based in San Francisco. He is the compliance head for 3 business units at Nokia. Prior to this, he was the global director at Nokia's Ethics and Compliance Investigations Unit. Bob is a former federal prosecutor, and immediately prior coming to Nokia, he was a partner at a US law firm where he specialized in conducting internal investigations and providing counsel on compliance matters. And last but certainly not least, John Chesley is a litigation partner in Gibson Dunn's Washington, D.C. office, focuses on white-collar criminal enforcement and government contracts litigation, represents corporations and executives in matters involving the FCPA, procurement fraud, securities violations, and whistleblower claims. He has significant trial experience and appears quite regularly in courts and other tribunals. So with introductions out of the way, I want to talk quickly about our agenda and what we're going to cover today. So I'll start by stating that this discussion is not intended to be a full review of the latest data privacy, protection, and transfer laws. I think there's plenty of great sessions over the past few days and tomorrow as well on GDPR and the US-EU Privacy Shield. So instead, we're really going to focus on practical guidance, tips and tricks from recent experience on how to navigate the inevitable challenges when conducting discovery abroad and staying in compliance with local data protection regulations. So we'll start by looking at the landscape. We'll look at recent trends with FCPA enforcement, which is really in large part driving many of us in this room to have to balance all of these data protection laws with discovery obligations in another jurisdiction. And then we'll look at the wide range of data privacy and protection laws at a high level, which pop up frequently so that we have a general understanding of the framework of regulations that are dictating how we change our e-discovery plans. And then we'll get into the specifics, looking at real case examples of scoping, planning, preserving, collecting, processing, hosting, reviewing, producing, closing out matters, how we do all of these things differently when we're talking about cross-border issues rather than good old-fashioned US litigation e-discovery workflows. And last, of course, we'll wrap up with a few key takeaways from the panel and certainly any questions from you all. So John, I'll start with you. You want to start us off by providing your take on any trends in the FCPA-related enforcement actions. We've got a chart here, shameless plug, from Gibson Dunn's year-end 2016 FCPA update.
Yeah, I like it. Well, thank you everyone for joining, and the 4 o'clock hour especially. So we've taken FCPA enforcement actions as a snapshot, I think, but those of us who practice in the international investigations field know it's more than just FCPA. It's cartel work. Perhaps you could even argue it started with criminal cartel work. It could be the international financial markets, tax. It is becoming an increasingly smaller world as regulators across multiple jurisdictions begin working more and more closely and develop relationships that then spawn new cases. So what you can see here from the chart on the left-hand side of the screen is we're seeing another uptick in FCPA enforcement. And for those who did read the year-end update that we put together last year, one of the trends we noted, and I think it's been borne out even since then, is increasing coordination across jurisdictional enforcement authorities. So examples from last year would include VimpelCom, where you had the Swiss and Brazilian and U.S. authorities. Embraer had Brazil and U.S. And there are several other examples. If you look at the Telia FCPA enforcement action recently, where you had, I believe, Swedish and Dutch and U.S. authorities. So the world is getting smaller and more challenging for us and all of our clients.
Thanks, John. So Bob, on the right-hand side here, we see a chart that's showing there's an uptick in matters which are involving cross-border discovery. Obviously, Nokia is a company with over 100,000 employees in 100 different countries, and you're headquartered in Finland in the EU. So I can't imagine that cross-border is the exception, but probably the norm for you. Can you shed some light or some insight into what that landscape looks like for you in-house?
Yeah, I was just on the phone with a colleague from Finland, so it's snowing there today, so bear that in mind when you complain about the cold rain here. Yeah, I mean, obviously one of the first people, I actually started with Nokia over in London, and one of the first people I was introduced to my onboarding process was our privacy officer. And really what I found out is it wasn't so much a single privacy officer as a privacy function that had to overlap and interact with everybody else, because, as you will see from another one of John's Gibson Dunn slides, it's just a hodgepodge of privacy laws that come about all through the world. And we really have to coordinate this thing up close. And what I'm talking about is not only GDPR, but I'm also talking about, particularly in the investigative side, we had investigations in the Middle East where the magistrate judge, which is essentially the prosecutor, was pounding on us to get documents, and we were being stopped by blocking statutes in 2 European countries because of that. So not only do you have data privacy regimes, you have blocking statutes. You also have overseas work councils, and a work council is very much akin to a union, if you haven't run into them, but much more pervasive than a union that sort of comes in, negotiates terms and benefits, and sort of stays away. They're actually a collaborative part of the management. And in fact, you know, Volkswagen, for example, has work council members on its board of directors. And so there's a constant need to pass through and vet privacy matters with the work councils. And then again, the other thing is, you know, China. China is a special thing in and of itself. China has not only the privacy laws, it has state secret laws, and so there's a lot to be going on. So it requires, and again, I mentioned that person, she's wonderful. She's a Finnish lawyer, and the chief privacy officer is probably the first person, and we'll talk about this later, that I call when I need to.
So we look at the map and we look at some of the kind of more well-known data privacy directives and laws that we see here. John, do you maybe want to go ahead and talk about the fact Gibson Dunn's obviously a global law firm, top law firm with offices all around the world. As a partner who's often doing investigations of far corners of the globe, how do you stay up to date on kind of the ever-changing landscape of data privacy laws and how you work within those?
So, you know, I think I found that the best way to stay current is, frankly, just to keep an active docket by, you know, just by working with the most sophisticated clients, the most sophisticated e-discovery vendors. We interact with the smartest people who are thinking about these issues, and just through those cases, you do stay up to date. I'd say that, you know, the first thing I'm looking to do is, rather than to be down to the ground level expert in every single jurisdiction, which frankly I couldn't do, I don't have the time to do that. The most important thing for me is just recognizing where there are potential trip points, and then identifying who is the right expert to turn to make sure that we step over them.
And Antonia, I guess continuing on that point, as we add some complexity to this, as someone who's involved on the service provider side and often getting requests to support in far corners of the globe, can you discuss some of these other lesser known data privacy laws that we've encountered?
Certainly. Yeah, everybody usually knows about China and the EU. They get a lot of press. There's a lot written about the GDPR or the state secrets laws. But when you look at the map, you see that almost every country out there has some sort of law, and they're not always stringent. They don't all block the data from leaving the country, but very often there's sanctions involved when there's non-compliance. And so, for example, we found ourselves recently in a matter in Colombia where, to be fully honest, I had never known that there was any sort of privacy or personal data protection. But as it turns out, personal data can't leave the country, and our client was very sensitive about that. And it took a lot of collaboration with local counsel, ourselves, and the client to figure out what data can actually be transferred for processing and review outside of the country. And so I think it's very important to remember that just because it's not well known or it's a jurisdiction doesn't get really a lot of attention, there might be something in there, and it's important to maybe talk to local counsel if there isn't a privacy officer at the client, and figure out if there's anything to keep in mind before we start actually just pulling data out.
So I think one of the first things that you're probably considering, Bob, whether it's a newly anticipated litigation or a whistleblower or regulatory inquiry, first you're going to think about the substantive issues. You want to understand the scope of the issue, where data might exist, who's involved, where they're located, which is going to kind of lead you down the path of starting to understand what's the legal framework I need to work within to conduct this investigation. So Bob, question to you. Who's your first call, or what's your first move internally when you're thinking about trying to understand how you're going to conduct this investigation and what laws you're going to have to work within?
Yeah, let me talk about it both internally and externally. I mean, obviously, you know, if it were up to me, I'd hire these two firms for every matter and go work on my tennis game. But we have to we have limited budgets to work with. So I think my first thing is to leverage internal resources. And again, I'm blessed with working for a European-based company that has been dealing with privacy for quite some time. So we have a fairly good framework in place where the privacy officer and the investigator would get together and do the first level of scoping and try to understand it. But it doesn't stop there. There's a two-step process. That first step is a really great debrief or detailed debrief by the investigator, because just because you're talking to a privacy lawyer, I tell the investigator, it doesn't mean he or she is particularly sensitive to compliance issues. So make a very broad explanation of what you have, what are the tensions, what are the rules you're required in terms of turning things over, give some examples, and really try to scope it out. But then after that, the second part of that is actually having a multi-function discussion, particularly in a large matter, in which we'll bring in cybersecurity, we'll bring in IT, we'll bring in HR, because it's surprising how much of HR has personal data. Sourcing is another tremendous volume of personal data, because they do a lot of their own due diligence before we bring a vendor on. So we try to, and you're absolutely right, Brad, it follows from the scope. Once we get the scope, everything sort of follows from that. And then it becomes, then do we go outside? Well, I think we go outside almost surely if the government has started the investigation and comes to us and says, by the way, you're behind the curve, we've already started the investigation. Then I think just to maintain the credibility with the government, to keep up to speed, that's when I think we go to external resources most often.
Got it. And John, from an outside counsel perspective, do you have any experience with international clients maybe being shocked about U.S. discovery and coming in and doing mass collections and saying we need to produce and get data over to the SEC or DOJ, or have they cited data privacy as an effort to maybe block those initiatives?
Yeah, so I guess it'd be a great war story if I could tell something like that here, but I actually have had the good fortune to work with really sophisticated clients who, if they are a global company, the U.S. is going to be an important market to them, and so all of the clients I've worked with, even abroad, have been pretty sophisticated about what is required under U.S. discovery. I think there's a saying I like that where you stand depends on where you sit. Everybody has different perspectives and different motivations for what drives them, and so there could be some resistance to turning over certain data or conducting searches in a certain way. I find that if you just talk to people and explain what it is that you need to do and why you need to do it, listen to them and what their concerns are, and then find a workable middle, I usually can come to resolution.
Got it. Thank you. So I guess now we're really into kind of drilling down further into the workflow. We're actually scoping the matter. We're thinking about specific custodians. John, what are some key adjustments you make? And I know most of your work is cross-border in nature, but what are some of the differences that you're going to do when you're scoping a matter that's international in nature versus a pure domestic case?
Yeah, I do miss the days of the purely domestic investigations where I can actually read the documents. But I think that the most important thing is to find the experts on multiple levels. So one, what are my data transfer limitations? Can I take the data out of country? Can I not? Before I collect, do I need a consent? Have the consents been taken as part of the onboarding employment process? So that's the first thing I'm looking at. Then once I figure out what my playing field is, then I figure out who my team is, and that is, sometimes Nokia does have resources around the world where they can do data collections, but not necessarily in every jurisdiction. No company does, and so oftentimes that's when you will need to turn to an external vendor. I'm looking at have I worked in this jurisdiction before? If so, who was my team the last time? Did they work out well? And if I haven't worked in a particular jurisdiction, I'm looking at to my colleagues to see who their recommendations are, because luckily we've been doing this long enough that we don't need to reinvent too many wheels, and we've got a pretty good network of people in place.
And Antonio, from the service provider perspectives, we're often engaged to help assist in that scoping effort, whether it's interviews or data map exercises. Can you shed some light on some of the kind of tips and tricks that you've employed from the project manager side in helping to corral all of that?
Yeah, I think where our value add really comes in is from our experience in a lot of these jurisdictions. Having worked with IT departments around the globe, we know what to ask and how to ask, really. I think data map sounds great, and I think in the US that's just a buzzword now, and that's where all the data resides, and you can even make a little visual out of it. But abroad, people don't really think of it in those terms, and just asking a few superficial questions might not get you the right information. So our job is to be there and ask those additional queries about, what is the retention policy? Is there anything that's actually currently auto-deleting as we're having this conversation that we need to stop? Are there any third-party providers? Some small clients might not have the infrastructure to actually retain their data, and so they outsource that. And that's very important to know, because that data is also on its own retention schedule. We ask questions around what devices are really relevant. A lot of countries also very much allow custodians to bring their own devices to work and use their own personal cell phone or their own personal computer. So how are we going to approach that? So it's very important to really delve deep into those questions. And if the first person you talk to doesn't have the answers, get another person. There's probably, maybe a local manager versus the head of IT, or the local HR person versus the head of HR, who might have very specific information that we can get from them. And our local team on the ground, we're very fortunate to have a lot of offices around the world. So they're always a great resource, both from a language and cultural perspective, to be able to have that conversation one-on-one and gain their trust and get all the right information.
And I think one of the things that we've had to do quite a bit on some of these international investigations, one particular scenario where at some point through our forensic analysis down the road, we realized that there was a lot of spoliation of evidence going on. There was a lot of reformatted hard drives around the same date amongst key custodians. So we started going back to some of those IT interview questionnaires and looking at responses, and started to see a fact pattern that had us a bit skeptical of whether or not IT was actually willfully spoliating or withholding evidence, or where that might exist, or perhaps involved in some of this reformatting. So we were able to look at SIM tools, so security information and event management logs, and go in, like Splunk is a good example, and get a sense of all of the different computers, access points where custodians had logged in with their credentials. So we were able to come back with a more comprehensive asset list, show that to IT, and then suddenly we were turned over many different laptops and desktops that previously we hadn't been presented with. So I think that's obviously an outside situation. I don't think that's going to happen on all international investigations, but I think it's certainly something that is a good way to validate what you're getting from your interviews. And also a best practice that you might apply domestically, just as another way to build out that asset list.
Brad, could I add something?
Of course.
And I just really want to elaborate, and you made a very good point, is the platforms that your employees use are astonishing to me, because we have certain policies as to what you can use, and we end up uncovering a lot of information off of WeChat in various regions of the world. They don't use a lot of email. They don't even use a lot of, we have like an internal chat Yammer line that we use, and a lot of it goes beyond that and goes into platforms and devices that we really have to fully understand. And particularly if it's a compliance investigation, that's where they go. They're not writing, hi, this is an email on official, Nokia email describing the conspiracy. It's usually in something very covert. So it can be a real problem. It's part of that scoping issue.
Yeah. So Bob, following up on that, I think part of your responsibility is responding to a lot of these issues. You don't just have a couple. I'm sure you've got multiple engagements, litigation, compliance investigations, internal government investigations going on. Can you walk us through what that playbook looks like so that you can respond to these and not reinvent the wheel each time?
Yeah, I think, again, the playbook, the only place the playbook deviates is when we bring in outside professionals. But again, I'm a bit repeating myself, but we wanted a scalable program, and we wanted a program where it became very rote to sort of go to privacy immediately. Sit down with that privacy and have that lengthy conversation. Bring in all the relevant stakeholders where the information could be, and don't just have one meeting. Have periodic meetings, and don't be afraid to bring people in midstream. So I think we really focus on because we find there's a surprising amount of data in areas that we don't even think data exist, and the more you question, the more you find that out. For example, we've done some conflict of interest investigations, and we were very surprised to see that there was things in HR files that really helped in terms of circumstantial evidence to sort of bring the conflict up to the front, and really sort of allowed us to really assess what the conflict was between what our employer was doing and the employer's relationship with an outside vendor. So again, to me, it's an organic process of constantly scoping, constantly bringing in new people. And then, of course, one thing I didn't mention when I was talking about bringing in the professionals is I really had an eye-opening experience being in London, because as you know, in London, the UK and in most European countries, there's no prohibition against fee sharing between lawyers and non-lawyers. So you have all the Big Four accounting firms have law firms there. There are service providers there that have set up private related entities that could keep the attorney-client privilege for you. So, I mean, there's always going to be a need for a Gibson Dunn, but if there's a scalable investigation that is small, that we can use one of the other vendors at a cheaper rate, they provide a tremendous amount of knowledge and allow us to keep the privilege.
So John, I'm going to pretend you didn't just say that.
Yeah.
Let's just pretend. We'll just go ahead and
Yeah.
pretend
It is
Right.
actually, I mean, it's the reality we're dealing with, and we actually work with a lot of clients to figure out, to put processes in place to make sure that they understand, okay, for the everyday matter, you don't necessarily need to hire an international law firm.
Right.
And
Right.
what are the protocol for running that investigation internally with in-house resources, and then what are the protocol for identifying the matters where you do need to bring in additional resources.
And you folks have been good about, like in Asia, where you have offices already, but you've pointed us to other people that I think, or other firms. So
Yeah, all part of our network.
So, assuming it is a kind of a bet the farm or a large government investigation, Bob, you are calling John for that, for support externally. John, what are some of the plans that you're going to make kind of initially from outside counsel perspective to help start moving the ball forward? We've kind of scoped, we're planning. we're getting ready for collections and preservation potentially. So what are your first moves?
So first moves are to, one, jump for joy. Two, I want to extract all of the in-house expertise that the client has, because there's one thing that clients will not come back to you again if you do, is if you reinvent the wheel that they've already created in-house. So figuring out if they've got a privacy expert who understands the regulations, if they've got in-house collection resources, that's what we want to know first. Next, I always like to try to get my hands on a small set of data, and it comes in all different types of ways. Sometimes you have a whistleblower who sent you a collection of materials. Sometimes you can do sort of a small scoping exercise, because I find that if you can do a small chunk of data review up front, it will really help you scope the rest of the matter a lot more effectively and a lot more efficiently. Who are really your custodians? What is your real time frame? And that's what I like to do up front.
So Antonia, from a service provider perspective, again, I think you're obviously maybe John's next call, and we'd be jumping for joy. What are some of the things that we're going to do then to start planning a cross-border dispute? Which stakeholders are we engaging? And I think also one of the points we can talk about is timeline management, because I think anybody who's worked on cross-border matters, there's a layer of complexity because of the distance between all the different stakeholders. So maybe you can talk to timeline management as well.
Yeah, so we try to, when we get that call, first thing I would do is look for people in my organization that have dealt with something similar in recent time. And thankfully, there's always somebody that has some experience that I can get some lessons out of, because as Brad mentioned, timeline becomes a big issue. For example, anytime we work with China, we're a whole day separated from them. So when I send an email in my morning, they're not going to get it until they wake up the next day. And so we can't keep playing tag every day. And so we need to be very organized, and we need to know exactly what we're trying to accomplish so that we can keep that conversation going. We just recently also experienced their full week national holiday too, which meant that no work was getting done. No one was present, either from the client or from our teams, even since they were also celebrating the holidays. So it becomes a bit of a problem when the U.S. law firm is asking for questions. The client is also potentially in-house counsel, is also U.S. based, and we need to coordinate with a completely different time zone, completely different jurisdiction. And so we try to use all of our previous experience to map out how long is it going to take to collect the data, how long is it going to take us to process that data, where are we going to put it once we have it processed, because the restrictions that we have around transfer. So we try to put that plan together before we commit to the deadlines that outside counsel is trying to ask us for.
And I think you can get yourself with the right amount of planning into a rhythm where you actually can use the time zones and leverage those to your advantage. So you can create that kind of 24/7 around the clock workflow with local folks in China from our team, and maybe local IT who are doing those collections. And there's a nice communication stream so that really you're actually getting better clock coverage.
Yeah, and that's one of the benefits of having a global footprint. I mean, the great news is the sun never sets on either Control Rest or Nokia or Gibson Dunn, and so we can do a 24-hour handoff. And I always try to bring in colleagues from our different offices who are in the local jurisdiction, so that we're always available if need be.
So we're getting at preserving and collecting data here. So Antonia, maybe you can talk about some of the tips and tricks you're considering when you're helping outside counsel and corporate client with preserving data in anticipation of that collection.
It's very important to remember that legal holds are now a part of U.S. litigation. Almost every U.S.-based company is well aware of them. They probably have one ongoing as you're talking to them. In international context, not every client is going to know what exactly a legal hold entails. And very often, even if general counsel does, that doesn't trickle down the line as much as one would imagine. So one of the things we always advise is get more stakeholders involved. IT is a great resource. Information governance people are a great resource. They not only know where the data is, but getting their buy-in during the legal hold writing process ensures that they also know what's expected of them once that legal hold is put in place, because they're going to be the ones preserving the data. They're the ones ensuring that nothing gets deleted either on purpose or just by accident. Involving people that are the heads of the business units that we're interested in, they can have a lot of additional information about different data systems that we didn't consider, perhaps even specific custodians that weren't even on the list that might be involved in the matter. It is important in international context to limit the hold to just the relevant custodians, so getting the information in advance of who those people are would be very useful. And we also really advocate using questionnaires, because it's a great opportunity to get additional information from each custodian while we're collecting the data. They can tell us which devices they used, which devices might have personal data, which is very relevant from a privacy context, and really additional information about what is out there, what was their involvement, even what other people were they communicating on that matter that we might not have considered already. Not to mention that anybody that's had to fill out that questionnaire, it does suggest they also read the legal hold and they understand that they were now under obligation to preserve their data. And we always say we have to document all of that. All of that needs to be well documented, both the holds, the responses, any additional answers to questionnaires, any additional reactions from custodians, any consents we might need to get. All of that should be incorporated in some way, and either using Relativity's legal hold or using any other process to incorporate that information actually in Relativity would be great, to link it to the custodians so that we know we have a clear map of, Joe got his hold in June, he responded in July, we have his consent, everything is linked, and we know that if ever challenged, we have that information. There's just a lot of little things around preserving the data that should be taken care of.
Yeah, and if I could just add to that, I think I haven't seen this as much in recent years, but a decade ago, I don't think that every multinational company had a legal hold on hand that they would normally do. I think now most companies do, and I always tell clients, don't let the perfect be the enemy of the good, because I think speed, time is working against you there, so you want to get it out as quickly as possible. And I had a case recently where we literally missed, the client had received in the United States a grand jury subpoena that related to activities in Asia, and completely innocently and independently, there was a planned data right-sizing scheme in Asia, and only because we were able to get that document hold out quickly did we avoid what would have been a very uncomfortable conversation with the prosecutor.
Yeah.
And something that we don't face at Nokia, but I know from talking to another in-house counsel who had a series of antitrust investigations against their company. And as you all know, antitrust investigations will take years to resolve. And they get heavy, and then they go quiet. They get heavy, they go quiet. And what they actually did was and these are my words, not quite his words, they actually put the document retention as part of the internal audit plan, so that they would go out and make sure that not just, you got it, you served, that it was actually being kept in place throughout that lengthy time period. Because I think time is an enemy of a document hold. It gets it can slip out at that point. So I thought that was really creative, is to sort of build that into an audit or a regular function to check.
And making sure that HR is on board, because employees will leave over the course of that lengthy
That's right, and that was another right.
Yeah, and
right.
you got to make sure that those laptops aren't getting recycled.
Oh yeah, oh yeah, exactly.
So let's talk about engaging local support. So Antonia, we talked about being investigative even with our interviewing and our data mapping, often kind of taking a no stone uncovered approach and really being diligent in how many folks we're interviewing and questioning to try and understand where data might exist. Can you talk about some of the things we're doing once we're actually on site? Our forensic examiners, they're there, they're collecting data. What are some of the considerations that are specific to a cross-border dispute or an investigation that you wouldn't deal with domestically?
So very often when we show up, we have to consider whether there needs to be any additional consents that we need to get from custodians, or from anybody at the company before we collect the data. So very important to get those in advance. Chains of custody become even more important in those situations because we want to make sure that the data actually was properly taken and it can be challenged later. But we're finding different and sometimes special little things that we have to keep in mind. For example, in some countries, a notary is required to be present at every collection. So we've had to, in advance, secure a notary to come on site and notarize each device as we're collecting and notarize each of the chains of custodies. Documentation becomes really important because as more information is uncovered, as more data comes in, we need to be able to track where we were, what we got, particularly if we're not going to be necessarily able to take all of it out of the country and verify it. If some of it is just sitting there being preserved, we want to make sure that we have the right information.
And so normally, typical case, we collect, we pack up our bag, we take our padlock drives, we've got the data encrypted, we're going to go back to the data center, start processing and hosting. So what are some of the things we're doing even on site before we leave the client premises, or certainly before we leave the country with that data? What can we do to help alleviate some of these data privacy laws?
I think to the extent that the data can be minimized before it even leaves the client side, we try to work with both the client IT, the client representatives, and usually the data privacy office to the extent there is one, to come up with at least some minimal strategies to eliminate personal data from even leaving the site. There's all sorts of ways in which we can accomplish that. All of these custodian interviews we talked about, IT interviews, knowing from the custodians even which perhaps folders or sets of data might not be necessarily relevant and leaving those aside. If data preservation is already in place, then maybe we don't need to actually take all the data out in one fell swoop. We can do additional search term culling, we can do date culling, we can pick and choose which custodians to start with. Really anything that can help us minimize the exposure to start, because we can always go back and get more as long as it's preserved. So it's important to take the approach of starting slow instead of just getting everything and dealing with it afterwards.
So now that we've got the data perhaps back to our in-country data center, we're starting to process, starting to host. And Tony, as the project manager on the service provider side, what are some of the technical procedures that you're employing that you certainly wouldn't have to handle if you had just one data center here in the US? Maybe you've got multi-jurisdictional issue, we have multiple data centers.
And that happens more often than not, especially since even if the investigation covers only one country, custodians happen to live all over the place. We currently have a case where, based in China, which has been both difficult and easy since all the data is there, but as it turns out, one custodian lives in the Netherlands. And so all of a sudden we have a European component in a completely Asia-based matter. So we try to standardize as much as possible our processes and make sure that we are consistent across the board. So that way there's no questions afterwards as to what we did and whether we handled a specific data set differently. One of the big things usually is how do we ensure that the client is not doing the same work twice. And so we've come up with creative strategies to duplicate data across different data centers through global deduplication tables, which don't have any personal information. We use the electronic signature of the file to essentially eliminate redundant information. And our effort is always to keep as much data in the jurisdiction that has the most coverage for the client as possible. So that way, the least amount of data remains where it's going to be harder to be addressed. We try to leverage the work product from one place to another, particularly when we use analytics. The analytics results can definitely be repurposed on new data sets, and we can use that information as well so that our clients or the review teams don't have to look at the same data twice.
So John, we worked on a matter that followed similar workflow where we had multi-jurisdictions and a tougher jurisdiction and a slightly easier jurisdiction to deal with. maybe you can talk through that as a case study of how you handled it from an outside counsel perspective and the strategy there.
Sure, and I'll absolutely second what Antonia said about, I think it's more the norm than the exception that you'll be dealing with data that resides in different jurisdictions that have maybe wildly divergent requirements for how you host, process, and review the data. So what I always try to do and I will make the shameless plug for Control Risk because they've worked with me very well on this, is I try to move the data to the place of least resistance where it's easiest to review. So if I've got a less challenging jurisdiction where I can bring the data to the United States and work with the review team here, I will make that my primary review site, and then they can, Antonio was telling me it's like M5 hash something. There's some process where they can compare the data between the two jurisdictional sets, and without importing or exporting or running afoul of any various legal regimes, they can do the deduplication. And so you end, for your more challenging jurisdictions, which frankly is often China, you can review the smallest subset of responsive data that just doesn't exist anywhere else.
So we've neared the finish of our review, perhaps, and we were getting ready to start to produce some documents finally, whether to the DOJ or SEC or the opposing party. John, any experiences you can share from maybe some of those negotiations behind the scenes with DOJ or SEC and how that went in terms of the format of production and things that they were going to be receiving from you?
Yeah. So I think I've been doing this enough years that I've kind of seen the progression. So I think 2007, 2008-ish was when multinational companies first became really sensitive to the data blocking or privacy regime areas, and so started putting up roadblocks to DOJ and the SEC, and they didn't like that so much. I think people have kind of become more sophisticated over time, frankly, on both sides of the aisle. And now, I mean, the key thing I am communicating to any regulator when I'm making a production is we will find a way to get you the data that you need to do your jobs and to give you comfort that you are receiving the fruits of a credible investigation internally, if that's what we're doing. But we need to do so according to certain parameters so that we are not running crosswise of some of our other regulatory obligations. And so, as long as I usually try to start with low-hanging fruit. If I have data residing here in the U.S. that I can make my initial production on, that's where I'll start to get them something. And then when it comes to, if I'm producing data from the EU and I need to do redactions for personally identifiable information, PII, typically that's not what DOJ and the SEC is focused on in any event. So as long as you explain what you're doing, and that's going to take a little bit longer, I've found them to be pretty reasonable in most instances.
More reasonable than even in civil litigation opponents.
Yeah, and there are certain agencies that can be less, but they'll go unnamed here.
Antonia, so as the person who's maybe running the production in Relativity, what are some of the things that you're doing from a technical perspective to help ensure that we are not running afoul of any of those data privacy laws?
So we during that time, the most important thing for us is consistency across all the production data. We want to make sure that all the information that was identified for redaction was redacted on every single document in a consistent manner, particularly because in every production there's going to be a lot of repeating information, and unfortunately human reviewers are the ones doing the redactions most of the time, and they get distracted and they miss a certain sequence of numbers, or they miss somebody's email address. That happens all the time, and to be fair, having done a little bit of that work myself, it's very tedious. It takes a lot of concentration. So we try to leverage the tool as much as we can to get more consistency out of it. Analytics is great for that, email threading, near deduplication, being able to group data sets in actual coherent groups and then just go through and make sure the redaction is consistently upright throughout the production is key. Otherwise, you're just looking at disparate documents all over the place. Using regular expressions for finding PII and redacting it, that's also important. We have our own internal team that does a lot of scripting, so they help us figure out ways to identify duplicate attachments and make sure that those are also treated in the same way. Really, any trick that Relativity has should be applied, because ultimately inconsistency is where they will get you, and that's where it becomes a problem. So that's usually where our project managers spend the most time before we get that production out the door.
So we made our production, so we're done, right? There's nothing else we have to do to comply with data privacy, data protection laws. And I think it's easy to think that. I think one of the things that's really paramount is closing out the matter. What are we going to do with all this data that we've collected, and we've processed and hosted, and it's perhaps in multiple data centers. It's with a law firm. It's with, you've got original media, you've got the original forensic images, you've got raw data, you've got production media, you've got potentially review providers. It's a different entity that may all have data, perhaps. Bob, what experience have you had in terms of maybe some of the challenges of, as the one who's closest to that responsibility of complying with these data privacy laws, some of your experiences there and kind of closing out and trying to dispose of this private data?
Yeah, I mean, you really touched upon it with your question. I mean, we've had surprising. Again, this goes back to trying to do the safe harbors in the U.S. and all those things, but it was a real challenge for us. Something we didn't really fully appreciate is that our investigations are done all over the world, but they're done in Europe also. But we happen to keep administrative people in New Jersey, and those people are the ones who control our database, which is a very non-substantive, just kind of like a flat-out, sophisticated Excel sheet that sort of keeps the progress of the cases going. It doesn't have any of the substantive material of the case in that database, but that triggered privacy concerns. So we were actually doing what I would call memorandums of understanding and agreements between two different functions within Nokia. As it was belt and suspenders, I will say that, but it just brought home to me that when you're closing out a case, or when you're opening a case, or even when you're progressing on a case, beware that while you're storing data at a certain point, custodians are in certain locations, you may actually have administrative people handling just the progress of the case somewhere else, and that could trip privacy concerns. So that was something that really surprised me.
Antonia, from a Relativity perspective or the service provider side, what are some of the things that we do to kind of account for all of where places this data may have ended up, and how we can assist outside counsel and the corporate client in bringing a close to this and disposing of data?
I mean, so the vendor usually ends up having the vast majority of the data associated with a case. As you mentioned, it starts from those forensic images, and then there's pre-processed data, there's processed data, it's on networks, it's on hard drives, it exists in a database, it exists in possibly another ECA database. So it's very important to keep good records of what we have, and I think that's what we contribute, is having a paper trail, and keeping that paper trail consistent across all these various devices and places. And we assign, well, some of the best practices we go with is assigning unique numbers to each ID, to each set of evidence, and keeping that consistent throughout the whole process so that we can track it down from Relativity all the way back to that hard drive that's sitting in our secure storage unit. And so, one of the other things that we've sort of started doing more recently is really using Relativity for all of that as well, having that information kind of hard-coded on a custodian basis, using dynamic objects, using additional free fields to enter and input and keep track of where all the data is, so that when Bob gives us a call and says the matter's closed, we can actually hand them over a very large hard drive.
Yeah, I gotta say, it's so important to do that because, I mean, the nature of our work is that, as Bob referenced earlier, sometimes you have something you think is done, and then literally years later it comes back from the dead. And I had a recent experience with that, and we needed, for a variety of reasons, to sort of recreate what we did for our investigation down to who were our custodians and what were our search terms in order to defend our investigation And luckily, I had my partner back in several years ago create a report on what were my search terms by custodians, because we all know that's a dynamic process. You start with one set of search terms with one set of custodians, then your investigation matures, you add search terms, you remove them, you focus your time frame, you expand your time frame, and you need to be able to go back and really recreate that. And so no investigation is complete until you really have that recorded in a place that, if ever you need it, and hopefully you don't, but if ever you need it, you can get it.
Right. So final key takeaways. Antonia, any words of wisdom for us?
I think as a outside provider, one of the most important things we can do is record all the information, keep track of everything, and make sure that we can document every step of the process we were involved in, because eventually, if anything gets challenged, it will get back to how did we perform the collection? Was everything forensically sound? How did we process the data? Where did we process the data? Did we violate any of those data privacy laws? So maintaining good, accurate records and making sure that everybody on the team is aware of the process is key.
Bob?
Oh, I would say two things. Well, one more for just the service providers out here. I think both of these folks have touched upon a very good point, which is you need to be project managers. I tell the attorneys who work for me now, you're no longer attorneys, you're project managers. The days of hiring a law firm, giving them a file and saying, take care of this and just don't bill me too much are over. You would expect to have the vendors, whether it's the law firm or anyone they hire, parse out on an a la carte basis the best cost-effective way to do something. And data preservation is one of those ways where it should be done scalable and in a cost-efficient way. And so you really admire professional firms that say, you could use us, we could do it, but it's going to cost you an arm and a leg. Here, this is this firm in this country with this language skill, has the right skill set, and they can do it. I think that's really important. John touched upon that very briefly, talking about not giving us memos. I mean, we have 2 captive law firms. That's the term, captive law firms. I don't know what that means, but we have a firm in Poland, and I have them working under guns over them. But there's a firm in Poland and a firm in India that provides us all our basic first and second year legal research that we need. So that's kind of one marketing tip. And the last tip I'll give is from the attorney perspective, which is you don't need to be a technical geek, and I'm certainly an example of not being the technical geek, but you really need to absorb what's going on. You need to ask questions, and you need to be in the weeds of this production, because you are the person that's going to have your deposition taken. You're the person who's going to be making representations in court that a stenographer is taking down. So you really need to understand what's going on. And I've overcome, there's no dumb question. I'll ask the stupidest questions, I think, as to keep understanding what's going on and make sure I get a handle of it in a flow sense as opposed to a technical sense.
And John?
So all great points. I guess the last thing I'd say is, I only generally get involved in things after something has gone wrong, and my job is to make sure that nothing gets worse on my watch. And so whatever bad has happened, we've got to stop the bleeding, and that goes to a lot of the points we've been talking about, how to run your investigation, make sure you preserve the data, et cetera, et cetera. Because I found, data deletion happens, employees do it, but whether it is viewed as a company problem versus an individual problem will depend on how credibly and how quickly you reacted for the investigation, and I think that makes all the difference.
Well, thank you. Any questions from the audience?
Sure. As more and more companies these days are storing their data in the cloud, what type of challenges do you face? Basically, companies, probably the U.S. company, and the servers might be in Europe or in Asia, and the backups might be somewhere else. How do you handle those type of cases? And how do you get the data?
You're right. It is becoming a bigger issue, and so it's part of that whole conversation we need to have with the right people to figure out where the data is and whether we have a right to get it. And I actually was just reading, there was a recent court decision, I guess, or
2016.
yeah, about whether or not data that's stored in the cloud in a different jurisdiction can be admitted in the same way. So, you know, to be honest, we have the tools to do it, and we get all the information around how to accomplish that process. Is a collection. It's not actually that much more difficult, but we do then consult with legal counsel to make sure that we're not going to run afoul with any privacy laws.
Yeah, I mean, from my perspective, I would follow the trace. So the data, if it's in the cloud, it came from somewhere, and you know, you can't sort of get around that jurisdiction's data privacy regime by going through the cloud and saying the data doesn't exist anywhere or exists everywhere.
Yeah.
Any other questions?
How do you see the privacy landscape changing internationally? Do you see more stringent data protections coming into place in various jurisdictions or less?
Well, it got more complicated with a certain Irish court ruling, which our firm is involved in, so I can't talk about.
You know, the blogs talk about, there's a fairly good, you know, what's going to happen in Europe is once this data privacy rule goes into effect, there are going to be multiple sort of libertarian challenges by people on the right to be forgotten. And so, you know, it's like anything in the world. This is going to change. You know, this framework that they're introducing, what, May 2018? Yeah, May 2018. That's going to get challenged almost immediately. So that's sort of like the opening salvo. And then I think that's going to be further refined. And as that gets refined, that reverberates to other countries. So, yeah.
Another question in the back of the room? All right, go Bob. Any others? If not, round of applause for the panel.
Great. Thank you.